Ladies and gentlemen, I just want to thank you for your time and attention this week. I know it's been a long week, and I know everybody's ready to get back home to their family, but very much appreciate it, and it's an important service in our community. And I promise I won't keep you too much longer. I know you've heard enough from us this week as well. Just briefly wanted to go back over the law briefly. I know the judge is going to go over that in more detail in a little while, but I just want to touch on it briefly. Like we discussed in jury selection, the child abuse statute. The injury for child abuse is described as cut, abrasion, bruise, burn, disfigurement, or physical pain. Any person who knowingly, other than by accidental means, treats a child under 18 years of age in such a manner as to inflict injury, that defines child abuse. We already defined the injury, and knowingly, we've defined that as well in the past. As far as aggravated child abuse, like I said, what differentiates that is the age of the child, under age 8 years, and it includes a serious bodily injury. And like it says on the slide, it includes, but is not limited to, a fracture of any bone, a concussion, severe bruising, and the judge is also going to instruct you that it includes what's called protracted unconsciousness. Protracted just means for a length of time, not like if you were to immediately fall asleep. Now, don't be confused. The state doesn't have to prove that Olivia suffered all of these. We don't have to prove that she suffered a fracture, she suffered severe bruising, she suffered a concussion, she suffered unconsciousness. We just have to prove one of those. The indictment does not say she suffered severe bruising, she suffered a concussion, she suffered a fracture. It just says she suffered serious bodily injury. Some of you agree that she suffered a fracture, but some of you don't agree that she didn't have severe bruising. That's okay, as long as all of you agree that she suffered some of this or one of these. That constitutes serious bodily injury. Now, let's talk about the facts that are not in dispute, okay? What's not in dispute is that whatever injuries you believe Olivia suffered that day, they occurred on January 9th, 2023 at Tylertown Learning Center in Montgomery County, Tennessee. And whatever injuries she suffered, they were suffered at the hands of Ms. Sarah Fuson, the defendant. Those facts are not in dispute. Let's talk about the bruising. You saw those bruises. You heard from Dr. Lakin, and you heard how those bruises were inflicted. You saw the video, you saw the photos of the bruises. Both Dr. Pena and Dr. Matches, the defense doctors, agreed that these bruises were inflicted by Ms. Fuson. Dr. Matches, on cross-exam, when I was questioning him, he stated that these bruises were not a severe injury, but he did state that these were severe bruises. Imagine the force necessary to leave an imprint of the clothing on Olivia's body. Imagine how hard you would have to squeeze somebody's arm to leave an imprint of clothing on their body and for it to remain days later. I submit to you that that's severe bruising. Let's talk about the concussion. You heard from Dr. Lakin. She believed Olivia most likely suffered a concussion based upon what she saw in the video, and that her head was struck repeatedly down over and over, and on the final time into the hard plastic edge that rendered her motionless. Unfortunately, we didn't have anybody to report any symptoms immediately following this incident for the next 4 to 5 hours. All we have is video, which shows Olivia sitting, crawling, stumbling around a little bit. And when they went to examine her at the Hopkinsville, which would have been 4 days later, nobody knew that she suffered a possible concussion. That wasn't until days later when law enforcement recommended to DCS that they contact the parents and have her evaluated further based upon what they saw in the video. Mr. and Miss Hyde did state that she was irritable, showing signs of irritability, but they had no reason to suspect that she had suffered head trauma. They weren't looking for anything. They could have missed something. Now let's talk about the unconsciousness prong. You heard from Dr. Lakin. She stated that a 1-year-old does not go from fussy and squirming around to totally motionless in an instant. And you heard that from Dr. Lakin, but use your own common sense. Let alone a 1-year-old, does anybody just fall asleep in an instant? The defense experts disagreed with this, but like I said, just trust your own eyes. Watch the video. I'm going to play it again here in a moment when we talk about the fracture, but watch the video as many times as you need to back there. Rewind it. Watch her go from squirming and pushing herself up to totally motionless after her head is slammed the final time. And I used the word slammed. The defense experts didn't use the word slammed. Ms. Fuson didn't use the word slammed. But that's okay. It doesn't matter what word I use or what word they use. You define what it was. You're the finders of fact in this case. Ms. Fuson stated she wasn't ready for a nap that's why she was forcing her down over and over, and then she said she finally fell asleep. The state submits to you, she was knocked unconscious. She didn't fall asleep. And I think the video proves that. Let's move on to the fracture. That's the big point of contention this week. The defense made a point of mentioning this week that law enforcement was the first to mention the word fracture, but that's simply not true. The first person to mention fracture was the radiologist at Vanderbilt, who said that this was a suspicious for fracture. They didn't say it's suspicious for a Wormian bone. They said it's suspicious for fracture. At the time the radiologist made this diagnosis, they had not seen the video. They hadn't seen photos. They hadn't seen the cot. They didn't know what was even alleged. They just knew suspected abuse. He looks at the scan, looks like a suspicious fracture, so that's what he notes. Dr. Lakin says it is a fracture. The three different defense experts call it a Wormian bone. Now, what is true is nobody used the term Wormian bone in this case until the defense brought up the term Wormian bone. You saw the examples of Wormian bones that Dr. Lakin provided. None of them look like the scan of Olivia's head. None. The defense experts had no examples of Wormian bones that look like Olivia's scan. It was a straight line, and it was not connected within the sutures of her skull. Dr. Matchis wants you to believe that with his virtual autopsy process, by inverting the skull and removing the top of the skull and putting all this intensity into it, I believe he called it, that he could make some sort of connection to make it a triangular shaped bone. That's simply not true. You heard Dr. Lakin explain that, and that's why the straight line was so much darker than the other portion, which was just a natural bump on her skull. The skulls are not smooth, as you heard from Dr. Lakin. Dr. Pena, he reluctantly admitted on cross-exam that if Olivia's head had hit the hard plastic edge, that it could have caused a fracture in the location we saw on the scan. He just said that her head didn't hit the hard plastic edge. And again, I disagree with that, and I'm going to play the video again one more time for you to see. And I ask you, again, to watch it in the back as many times as you need to, rewind it if you need to. Watch, I'm going to stay quiet, but watch the final time that she is slammed down. Watch where her head hits. And then when you're back there, get that cot. Feel the edge of that cot and see where her head hit. Like I said, you could decide where her head hit for yourself. As I said, you're the finders of fact. Watch that in the back as many times as you need to. Grab the cot, feel the cot. Do what you need to do with that. But you decide where her head hit, not me, not Dr. Lakin, not Dr. Matches. You do. Now, Dr. Lakin is also the only doctor who had all of the information in this case. The radiologist, all he had was the scan. He didn't have the cot, he didn't have the video. Dr. Hinkes, Dr. Matches, and Dr. Pena, they had the scans and they had the video and the photos. None of them ever saw that cot in person. They never laid a hand on that cot. They can't see that there's a hard plastic edge underneath the mesh at the end of that cot. I'm not saying they're lying. They may have thought her head only hit the mesh because they never inspected it. I'm asking you to inspect it, feel where the plastic is, watch the video, see where her head hit. She's also the only doctor who testified here today that's totally unbiased. She hasn't been compensated for her testimony. She has no dog in this hunt. She's simply doing her job. And her job is to protect children, and that's what she's doing. Now, when the defendant was testifying, you heard her say she wouldn't want anyone to handle her niece Willow the way she handled Olivia. And I asked her why. She said because she loved her niece. Well, Macy and Thomas Hyde love Olivia. And she did not deserve to be treated that way. And the state is here to ask you to hold her accountable for the way she treated Olivia and the injuries she caused to her. And I'm going to ask you to find her guilty of aggravated child abuse and child abuse. Thank you.
I also want to thank you for your time and attention this week. I know it can be sort of a hardship to be separated from your families and having to make arrangements for work and things like that. I just want you to know that I recognize that this is a hard job to come down here and sit as a juror in a case like this, and we do appreciate your work. You all have probably heard of the telephone game. It begins with a group of people either standing in a line or sitting in a circle, and one person whispers something in the ear of the person right next to them. Then that person attempts to repeat what they heard or what they thought they heard to that next person in line, and this continues one after the other until the end. And then in the telephone game, the last person tells the group what he or she heard. And the whole point of that exercise is the incredible difference between what the first person said and the last person heard. Yesterday morning in this courtroom, we all learned, and I was surprised to learn it, that the telephone game seems to be alive and well and being played in the world of criminal investigations. And let me tell you what I mean by that. I'd ask you to search your memory, and if you took notes, to look at your notes about the testimony that you heard first thing yesterday morning, which seemed to be, to me, the day started that it would be sort of mundane, Wednesday, rainy day testimony. But there was testimony from Caleb Sherman with the Department of Children's Services, Alan Pendarvis from the Clarksville Police Department, and TBI case agent Jonathan McGowan. They were all advanced as witnesses, one after the other. And I just sort of want to set the scene for you because I think this is important. On January the 19th, 2023, that was the day that Olivia was seen at the Monroe Carroll Children's Hospital in Nashville for the CT scan. On that day, and try to remember the testimony, the TBI case agent McGowan spoke with Detective Alan Pendarvis from the Clarksville Police Department. They had a telephone conversation. The Clarksville detective, Mr. Pendarvis, tells the TBI agent, Mr. McGowan, that he received a case referral in relation to Olivia Hyde. Then Pendarvis recommends to Caleb Sherman that Olivia be medically evaluated at Monroe Carroll. And presumably, Mr. Sherman calls the Hydes and she ends up at Monroe Carroll. Later, Detective Pendarvis calls Sherman, and Sherman said that he was told, I'm going to emphasize he was told, that a hairline fracture, quote unquote, a hairline fracture was found during Olivia's CT scan at Monroe Carroll. And ladies and gentlemen, that phantom skull fracture, that non-diagnosis or diagnosis, however you look at it, was born. What was seen at Monroe Carroll as a linear lucency that was suspicious for fracture, as a result of that telephone tag they were playing on January the 19th, it became a hairline fracture. And the significance of that is it formed and shaped the opinion of the investigators in this case. And every law enforcement document that was produced from January the 19th, 2023, when this phantom diagnosis was not communicated properly between the police officers and the investigators, that became what was perceived by them to be a fracture. And between January the 19th of 2023 and the date that the indictment was returned in this case in April, that's what they thought happened. And I'm sure when Mr. McGowan, since that's what he was told, appeared before the Montgomery County Grand Jury and presented his short summary of the case, I'm sure that that was on his lips, that there was a hairline skull fracture. And the group of citizens that returned the indictment that brings us here to court today were likely told that very explosive phrase, hairline skull fracture, being sustained by a 1-year-old. You may remember the testimony of Caleb Sherman, sort of a small irony in all of this. I asked him who had told him about this hairline fracture. He's no longer with DCS, based on his testimony, and he said he couldn't remember. So to me, that revelation that we heard Wednesday morning about how this whole thing got started was more significant than the pitched battle that we saw yesterday and carried over until this morning between these earnest experts. I think it became a key to understanding how a linear lucency suspicious for fracture became a skull fracture and set all of this week in motion. I want to talk a little bit about the medical proof. I know you're probably up to here with the medical proof, but just a few things that I thought were significant that I hope you will consider when you go back there and deliberate. According to the state's opening closing argument, they want you to go back there and just watch the video over and over and over again. But I'd ask you to go back there and consider the testimony as well and the proof that you heard. We're starting with the premise of a CT scan that showed a linear lucency, but significantly, ladies and gentlemen, I'll ask you to talk about it today when you're deliberating, no intracranial abnormality. And I sort of had to pry it out of Dr. Lakin, but I think she grudgingly agreed that that means that in this case, there was no traumatic brain injury to Olivia Hyde. There was no damage to Olivia's brain caused by the accident or whatever you're seeing on January 9th or other trauma. Dr. Matches testified, and you heard him yesterday. He wanted to be here, but due to the government shutdown, he was not able to get here. Dr. Matches had conducted a virtual autopsy with some very advanced CT review of the raw CT data and a 3D reconstruction. He testified to you yesterday that the virtual autopsy revealed no skull fracture. And looking at all the hospital records, that opinion is supported. There was no residual swelling. There was no sign of healing. There were no breaks. There was no depression of a bone into Olivia's skull. There was no bleeding. What Dr. Matches told you, based on the advanced techniques that he uses, he found an accessory suture consistent with a wormian bone, a normal extra piece of bone. And I asked Dr. Lakin this morning about the radiological, if I'm pronouncing that correctly, significance of this whole wormian bone in the calculus of this type of a case. And she agreed with me that it's important because a fracture can be confused with a wormian bone. Let me say that again, and she acknowledged that. And Dr. Lakin doesn't really like to acknowledge facts that she finds inconvenient. The significance of this presence of the wormian bone is that it could undermine and should undermine the state's prosecution of this case because it can give a false positive of a fracture. On January 19th, 2023, I just have a few more comments about the medical proof that you heard. There was, when Olivia went to Monroe Carroll Children's Hospital, there was a full trauma series of x-rays, a full blood workup, and a CT scan. And when you get back there and talk about these records, there was an x-ray that was taken of her at Monroe Carroll in addition to the CT scan. The x-ray offered no evidence of fracture or other bone abnormalities. I think you heard that this week. Both the soft tissues and bone density, which were evaluated by the skeletal survey that you also heard about this week, were within normal limits. Images of the spine, abdomen, arms, and legs revealed no extensive bruising. You heard Dr. Matches acknowledge that the actions of Sarah Fuson did cause the bruising, but he said that they were not consistent with severe injury and not consistent with assault. That those marks resulted from rough but non-assaultive handling. He also said that there was no evidence of any high energy trauma, skull fracture, or brain injury. We also learned in an evaluation of all the medical proof that all the vitals analyzed in the blood test that was done at Vanderbilt were within reference range and normal. I'd like to talk about that Tylertown video, the troubling video that you're going to have to confront and deal with in trying to arrive at a fair and just result in this case. I'd ask you, as rough as that looked to you, and please discuss this, ask yourselves when you get back there, does anyone really believe that 22-year-old Sarah Fuson, who has an associate's degree, this is one of her first jobs as a young adult, knowingly and intentionally set about to inflict serious bodily injury on Olivia on the first day of Olivia's school in the toddler room? I think that's an important question, and it's a hard question that you all will have to consider and answer. Or is it more likely that Sarah was hustling in the room, multitasking in the room? She's got 6 children that she's taking care of, and that she acted recklessly. At the end of the arguments, the judge is going to read you what's known as the jury charge, the law that the judge is going to ask you to consider in evaluating the proof in this case. And I would ask you to take a look at it all. It's all important. There's not one thing that's more important than the other. But I would ask you to take a look at in my copy would be page 7, there's a definition of the term recklessly. And I think the judge will tell you in a few minutes, and I'm not going to read the whole thing to you, but I think the judge will tell you that recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial risk. That's not the whole instruction, but I would ask you, in evaluating what the appropriate mental state for Sarah Fuson on January the 9th, 2023, when she was dealing with those children in the room, what was her mental state? I've already suggested to you it was not knowing, it was not intentional, that I'm suggesting that it was a reckless mental state. Obviously, that's all for you to decide. When we began this on Tuesday morning, I think the last thing that I told you in my opening statements still sort of holds, and I still think it's apt to your consideration of this case. You have a lot of jobs and duties as jurors, but what I told you on Tuesday morning, I think still remains. It's not your job to go back in the jury room today and solve this case as to whether you think that Olivia Hyde sustained a skull fracture. If you get back there and you can't decide if she, based on all of the evidence, the defense proof, the state's proof, then the state has not done its job in convincing you beyond a reasonable doubt of the guilt of Sarah Fuson. And if you find yourself in that position, it would be your duty to acquit Sarah Fuson. Now, there are many charges that the judge is going to read to you in the jury instructions. There are lesser included offenses. And when I was directing your attention to the concept of recklessness, I would ask you to consider those offenses that deal with the mental state of recklessness. And I appreciate your time and attention this morning, and I thank you for your service on this jury.
Mr. Moore?
Members of the jury, I get to go last because the state has the burden of proof. You've heard that several times, but I hope not to be too long in summing this up, because the sooner I sit down, the sooner Judge Wolfe will read the final jury instructions, and the sooner you'll be able to deliberate on this case. And the sooner we will know what the truth is by your verdict. And the truth the state submits is that this defendant is guilty of child abuse and aggravated child abuse based on everything that you have seen and heard. Like Mr. Triance, like Colonel Holder, not going to read the instructions that the judge is going to give you, but one thing I wanted to say, and this is in response to Mr. Striance, the way I read it is like, oh, well, just pick and choose, go down, forget about intentional or knowing. Well, the judge is going to tell you, I submit, that the charge, the element is knowing other than by accidental means. Even the defense experts told you this wasn't an accident. She knew what she was doing. And she was getting paid for it. Whether it was $10, 10 cents, $100, or what was it, Dr. Matches gets $550 an hour. She had a duty to that child. And the first duty is to do no harm. Jury instructions. One of the things that Judge Wolfe's going to tell you what we lawyers call sequential jury deliberation. You don't pick and choose. You go down the list. You start with the highest charge. And if you believe the state has carried its burden of proof, which I submit to you we have, the verdict should be guilty. That's the oath you've sworn. Do justice. Only if all 12 of you who go back into the deliberation room for some reason find that she is not guilty of aggravated child abuse do you move down. Don't just jump down. I understand why Ms. Stryance would want you to, but that's not the way the law works. And the business about this being a telephone game, because who started this in the first place? Ms. Fuson. But who started the reporting? Sabrina Carter. That's her duty under the law, and she followed it to a T. She began the investigation. She communicated. DCS worker, detective from Clarksville, on to Agent McGowan. Okay, so which one of them should have dropped the ball? Which one of them should have not made a call? Should have just let this go by the wayside? They communicated. The case was investigated. You've heard the proof. You've seen it. And that blue cot laying over there, you can take it back and you can feel it. Talked about believability of witnesses. Those same rules of how did the person impress you? Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? So on and so on. Common sense, how we judge people in our everyday lives. And Ms. Fuson judged by those same rules because she'd taken the stand and testified. Members of the jury, if there ever was someone who testified from the stand and had no concept of accepting responsibility for what she did, you heard it this morning. And of all the unmitigated gall to sit there and say Olivia Hyde's mother is a liar, I will submit there are two sets of good parents in this courtroom. Fuson's and Olivia. But they're not the ones on trial. They didn't do this. Sarah Jo Fuson is responsible like any adult. That is the purpose of the criminal law. That all people are accountable for their actions regardless of their station in life or anything else. Accountability. And we heard many times about how fortunate that this was not worse. So we had the virtual. Moment that last eighth slam took place, and Olivia Hyde never moved again. What did she tell you? That was her lunch break. You are the judges of the credibility, the believability of the witnesses. do believe that some witnesses did not tell the truth or were motivated by some other reason, be it accused of serious crime. And this is a serious offense. Probably, at least hopefully, never see something like this again. But it happened. It happened, and Sarah Jo Fuson is the one who did it. All this I submit on behalf of the state of Tennessee is not reckless accident, not a rough handling. What you call, what you saw, and what you've heard the last few days, aggravated child abuse, that's what it's called. What do you do about it? I respectfully submit what you do about it based upon the state having proven this case beyond a reasonable doubt is to come into this courtroom and return a verdict of guilty of the charged offense. Thank you very much. I submit the case to your consideration.
All right, ladies and gentlemen, you will now receive your copy of the final charge. Ladies and gentlemen, if you'll follow along with me. The defendant, Sarah Jo Fuson, is charged in the indictment in count 1 with aggravated child abuse. Necessarily included within a charge of aggravated child abuse are the lesser included offenses of aggravated assault, reckless aggravated assault, child abuse, assault, and reckless endangerment. In count 2 in the indictment, the defendant is charged with child abuse. Necessarily included within a charge of child abuse are the lesser included offenses of assault and reckless endangerment. The defendant pleads not guilty to each and every offense embraced in the indictment. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The law presumes that the defendant is innocent of the charges against her. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. And this burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case, and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Montgomery County, Tennessee, and that it was committed before the finding and returning of the presentment in this case. The burden is upon the state to prove by a preponderance of the evidence that this offense was committed in Montgomery County, Tennessee. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced and consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Montgomery County, Tennessee, then you must return a verdict of not guilty. Excuse me. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime for which she is charged. In considering the identity of a person, the jury may take into consideration all of the facts and circumstances in the case. The court further charges you that if you are satisfied from the whole proof in the case, beyond a reasonable doubt, that the defendant committed the crime charged against her, and you are satisfied beyond a reasonable doubt that she has been identified as the person who committed the crime charged, then it would be your duty to convict her. On the other hand, if you are not satisfied with the identity from the proof, or if you have a reasonable doubt as to whether she has been identified from the whole body of proof in the case, then you should return a verdict of not guilty. As heretofore stated, in count 1, the defendant is charged with the crime of aggravated child abuse. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly, other than by accidental means, treated a child in such a manner as to inflict injury. And 2, that the act of abuse resulted in serious bodily injury to the child. And 3, that the child was 8 years of age or less. Serious bodily injury to the child means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, an organ or mental faculty, or a broken bone of a child who is 8 years of age or less. Serious bodily injury to a child includes, but is not limited to, second or third degree burns, a fracture of any bone, a concussion, subdural or subarachnoid bleeding, retinal hemorrhage, cerebral edema, brain contusion, injuries to the skin that involve severe bruising, or the likelihood of permanent or protracted disfigurement, including those sustained by whipping a child with objects. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct, when the person is aware of the nature of the conduct or that the circumstances exist. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct when it is the person's conscious objective or desire to engage in the conduct. If you find the defendant guilty of aggravated child abuse as charged in the indictment, you shall so state. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of aggravated child abuse, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intentionally or knowingly caused a bodily injury to another, and 2, that the act resulted in serious bodily injury to another. Bodily injury, serious bodily injury, knowingly and intentionally have already been defined. If you find the defendant guilty of aggravated assault as the lesser included offense of aggravated child abuse, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of aggravated assault, you shall then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of reckless aggravated assault. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant recklessly caused bodily injury to another. 2, that the act resulted in serious bodily injury to another. Bodily injury and serious bodily injury have already been defined. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct, when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted knowingly or intentionally. Knowingly and intentionally have already been defined. If you find the defendant guilty of reckless aggravated assault as a lesser included offense of aggravated child abuse, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of the reckless aggravated assault, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of child abuse. Any person who commits the offense of child abuse is guilty of a crime. For to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant knowingly, other than by accidental means, treated a child under 18 years of age in such a manner as to inflict an injury, and that the child, two, that the child was 8 years of age or less. Knowingly has already been defined. If you find the defendant guilty of child abuse as a lesser included offense of aggravated child abuse, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of child abuse, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant caused bodily injury to another. Two, that the defendant acted either intentionally, knowingly, or recklessly. Bodily injury, recklessly, and knowingly, and intentionally have all already been defined. If you find the defendant guilty of assault as a lesser included offense of aggravated child abuse, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of assault, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of reckless endangerment. Any person who commits the offense of reckless endangerment upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury, and that the defendant acted recklessly. Serious bodily injury, recklessly, knowingly, and intentionally have already been defined. If you find the defendant guilty of reckless endangerment as a lesser included offense of aggravated child abuse, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of reckless endangerment, then you shall acquit the defendant of this offense and proceed to count 2. As heretofore stated, in count 2, the defendant is charged with the crime of child abuse. If you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant knowingly, other than by accidental means, treated a child under 18 years of age in such a manner as to inflict injury. And two, that the child was 8 years of age or less. Knowingly has already been defined. If you find the defendant guilty of child abuse as charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of assault. Any person who commits an assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements, and the elements for assault have been set out in count 1. If you find the defendant guilty of assault as the lesser included offense of child abuse, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of assault, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of reckless endangerment. Any person who commits the offense of reckless endangerment upon another is guilty of a crime. For to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements, and those elements have been set out in count 1. If you find the defendant guilty of reckless endangerment as a lesser included offense of child abuse, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to her guilt of reckless endangerment, you shall acquit the defendant of this offense. During the trial, you heard expert testimony. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, A witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness. It is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background and training or experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all of the other evidence in the case. The defendant having testified in her own behalf, her credibility is determined by the same rules of credibility of other witnesses is determined. You will give her testimony such weight as you think it is entitled. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. During your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The verdict must represent the considered judgment of each juror. To return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as the foreman or forelady who will preside over your deliberations. When you've reached a verdict, you will return with it to this courtroom and your foreman or forelady will announce it. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find her guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to her guilt, then you must find the defendant not guilty. You will be provided with forms for all possible verdicts in this case. The jury will complete the appropriate verdict form and your foreperson will sign the appropriate verdict form. The crime charged in each count in the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all offenses charged. Your finding as to each crime charged must be stated in your verdict. In reaching your verdict, you shall first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, then you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or if you have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you have unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. Now, ladies and gentlemen, before you retire to begin your deliberations, I will select the two alternates, and that will be by randomly selecting the numbers. Mr. Chandler, you are an alternate, so that means you will be able to step down and just return your pad to the notepad to the bailiffs. Is there anything in the jury room that you need to retrieve? All right, if you'll escort them out through the hallway, please. Thank you, gentlemen. Ladies and gentlemen, the remaining jurors are our trial jury that will decide this case. We are now at the noon hour, so we're going to go ahead and instruct you to go ahead and before you begin your deliberations, let's go ahead and take a lunch hour. When you come back, before any discussions occur, before any consideration of the evidence occurs, make sure that all 12 people are present in the jury room, and you cannot discuss this case. If one of you is in the bathroom, stop all discussions. Don't do any discussions unless all 12 of you are in there at the same time. And if you need anything from us, let us know. If the exhibits, the hard exhibits, will go back with you to the jury room. If you need to, usually I know it was said you could watch the video as many times as you want to back there. We typically bring you back into the courtroom and watch it in here so that everyone can see those parts that you watch. And because they're on a thumb drive and a computer is necessary, it is more advantageous for us to have you come back in. So if you want to watch any of the videos again, just let the bailiffs know and we'll bring you back in and we'll play whatever portion you want. All right? So we will now allow the jury to retire, take their lunch hour until 1 o'clock, and then be back together in the assembly room down below, and we brought up together as a group to go into the jury room to begin your deliberations at 1 o'clock. All right, thank you. What are you doing? Oh, and ladies and gentlemen, I am sending back, have everybody come step back in for just a second. You don't have to sit down. I failed to instruct you that I have prepared a verdict form that was mentioned in those final instructions, and you'll see that it goes down through count one. In the count one, it shows that on the charge of aggravated child abuse, we, the jury, found the defendant either not guilty or guilty, and you check one depending on how you find it. And again, you move through each one of the lesser included only after you've dealt with the first one. Hopefully that will help you understand what you're doing. Thank you. Now you can go. This court will stand in recess pending the return of the jury. And our process here is usually to, even though there is a TV in the jury room, we have traditionally brought them in here to watch any sort of video. So Mr. Holder, if you'll get it ready to play, we will bring the jury in as soon as we're ready. All right, ladies and gentlemen, I've been handed a note that you have requested to rewatch the video footage of nap time, so we will play that for you. Excuse me. Ladies and gentlemen, if anyone indicates that you want to watch that again, all right, they've requested to watch it again, please. All right. Ladies and gentlemen, if you would like to retire to resume your deliberations, thank you. I'm sorry?
I wanted to put something on the record if I could.
All right.
The jury had a question, I think it was approximately 1:42, so we were notified that the jury had a question on the version of the video. Brought them in about 1:45, and they watched that Zoom version of the video. Asked the court to consider on Tuesday morning, or Tuesday, the first day of trial, there was a longer version offered as evidence by the state, which shows a longer period of time than I don't know if they were interest motivated and want to see it because they're against trying to see it because they were trying to evaluate the testimony about the confession. I would request that they
Well, you're asking me to bring the jury back in and without their request, make them watch a different version than what they requested, is what I'm understanding.
realize it's unusual, but just in terms of
Would it not be reopening the proof to do that? One thing to allow a jury to ask a question or a jury to come in and say, we'd like to rewatch something. They specifically stated in their note, we would like to review the up-close video footage of nap time. And that was what they asked. So that's what they were shown. And so you're now asking that I bring them back in and I have them watch a longer version, which is not something they requested.
I just was concerned that they may focus on a version.
That is their prerogative to look at the evidence and to assign the weight that they think is appropriate. So I understand your position,
Yes, sir.
and I am going to deny your request, but it's obviously on the record now, and I'm denying the request because the only reason they were brought back in and shown that version is that's the version that they specifically requested. So,
Yes, sir.
all right,
Thank you.
then we'll stand adjourned. Anything else then before I recess?
sir.
All right, we'll be in recess again. Please be seated. All right, I'm advised that the jury has reached a verdict. So I'm going to bring the jury in. I would just simply, this is a case that has had a lot of emotion in it. And I just want to caution everyone that the jury is I'm going to go over their verdict with them, find out what they've decided. Once I do that, then obviously we'll deal with what's the next step, if any there is. But I want to make sure everybody understands there's not going to be any displays of emotion or outcries or anything. The jury has given this matter their full attention for these 3 days, and I'm going to treat them with as much respect as I can, and I expect you to do the same. Bring the jury in, please. All right, ladies and gentlemen of the jury, I've been advised that you have been able to reach a verdict. Is that correct? Would your foreman or four ladies stand, please? I'm going to go over the verdict form with you, and if you will affirm for me what the jury's findings are. As to count one in the indictment for the charge of aggravated child abuse, how does the jury find the defendant, Sarah Jo Fuson, not guilty or guilty? As to count two of the indictment, you find the defendant guilty of count one. In count two of the indictment, as to the charge of child abuse, how do you find the defendant either not guilty or guilty? Guilty. So both counts one and count two, the defendant has been found guilty by you. Is that a unanimous verdict of all 12? Raise your hand if you will, please, to signify that it is a unanimous verdict. All right, show that the verdict is unanimous, and therefore the court affirms that verdict. Ladies and gentlemen, I know this has been a difficult case, and it's not any fun for you to have to participate in it. I'm going to order that you be allowed to escort you out through the same way that you've been coming in so that you can have some privacy and get on. If you've got anything in the jury room, turn your badges in, and then you can go on about your business. This will conclude your jury service. So if you need a note from the clerk will. All right, she'll come and meet with you in the jury room and give you the note. So thank you for your service, and you may now be excused. So. All right, the next step will be to set a sentencing hearing. We'll order a pre-sentence report, and then we'll need to set the sentencing hearing date. Usually that's conducted within 45 days. We can state have a position on need to check how quickly we can get it done. I'm in Cheatham County in the month of November, so that would be when we normally would do that. Anybody have any opposition to going to Cheatham County to have the sentencing hearing? All right. We could do it in Cheatham County. Can we get the pre-sentence report done that quickly? I am here December the 4th, so that might be the most advantageous. Let's just do that. We'll set this for, is that a trial, State versus Jeremy Lane? Got the sentencing hearing at a specific time. Let's set the sentencing hearing at 1 o'clock on the 4th of December. Or we could do the 11th. 11th of December, is that available for? Let's do it at 9 o'clock on the 11th of December here in this courtroom. So. Now, I'll allow counsel to be heard, but this is a Class A felony which carries a mandatory minimum of time that would require the defendant to be taken into custody at this point. So I'm going to order that she be remanded into the custody of the Sheriff's Department, and she will be held there until the sentencing hearing of December the 11th. So. All right, this court is adjourned.